Hello, merhaba. İstanbul'dan merhabalar. Hello from Istanbul. We are going to present legal judgment prediction and availability of machine learning jurisdiction. You can see my project team. You can see find details in the booklet. So today I'm going to present my this study with my colleague, Professor Kaplan, who is an assistant professor at School of Business, and I am assistant professor at School of Law. So our work focuses on four main topics. These four titles are designed to reveal the results we want to examine systematically. Part one is the organic and functional structure of Turkish judicial system. Part two is anatomy of judicial decisions. Part three is data pool and accessibility. And part four, legal judgment prediction in Turkish judiciary. It should be noted at the very beginning of the presentation that in this study, we are trying to put forward the right questions and methods that will lead us to more research instead of a precise and clear numerical similarity results. In this context, we aim to determine the studies that need to be done in terms of Turkish law and Turkish language, and to reveal the way to be followed. We are in search of whether it's possible to reveal a fair trial decision with an NLP method. For this reason, we identified the deficiencies we encountered in studies conducted with similar aspects in Turkish law, and try to present a systematic approach by considering them. I hope we can ask the right question, and by executing the right ideas, we can come up with a framework for Turkish law. So this section consists of three subtitles, as you can see. I'm going to explain these three subtitles. Turkish judicial system, according to Article 9 of Turkish Constitution, the judiciary, one of the three main organs of the state, is administered by independent courts. There are many courts in Turkish judiciary organization that belong to different judicial branches, the scope of which is determined by both constitution and the laws. Turkish legal system is divided into three branches. One is ordinary justice, administrative, and constitutional courts. Each jurisdiction has its own unique trial procedure, and each has a different high court. This demonstrates that Turkey has adopted the judicial separation system. The judicial separation system leads to emergence of different types of decisions and judicial process. This situation as a data set causes different data types in the judicial decisions data sets. So also we have an ADR, alternative dispute resolution, in our Turkish legal system. Instead of litigations, various alternative resolutions have been accepted in order to establish social peace within the Turkish system. Unlike judicial proceedings, alternative dispute resolution methods seek to resolve disputes between parties in a free and open manner without determining which party is correct. Mediation, conciliation, and arbitration are alternative dispute resolution methods used in Turkish law. For labor, commercial, and consumer disputes in Turkey, it's mandatory to consult with a mediator before filing a lawsuit. Mediation in other types of legal disputes is determined by parties' willingness. Although the mediation decision is different from the court decision in terms of legal characteristic, although they are not binding on court decisions, they can be considered as decisions that should be taken into account if we want to teach the functioning of the justice mechanism to algorithms. A court decision is a decision made by a judge at the end of the process in which both parties see themselves as justified. On the other hand, the mediation decisions is a decision that both parties consent to, approve, and consider to be fair. Perhaps it will be appropriate to consider the mediation decision made in that country as well as the court decisions in the studies to be conducted on NLP and machine learning. So the system of the judicial separation has been adopted in Turkey, the types of courts and higher judicial bodies to which these courts are affiliated are different. These distinctions is reflected in court decisions as well. Many of these are not trial-ending decisions. The number of final decisions, on the other hand, is quite large. Other than acceptance and rejection decisions, peace decision, decision to consider the case not opened, decisions of non-jurisdiction have final decision in or civil courts. On the other hand, administrative jurisdiction is perhaps the easiest to classify decision types among first instance courts. Administrative jurisdictions perform their judicial function in two basic ways, namely interim decision and final decision. As the final decision in administrative jurisdiction, in annulment cases, the dismissal of the case or the annulment of the transaction is decided, while in the full remedy cases, the dismissal of cases or compensation is ruled. And we have a Council of State and Court of Cassation. The decision of Council of States and Court of Cassation approve or reverse the decision of the first instance and regional courts. The approval decision upholds the lower courts and district court decision. Reverse decision, on the other hand, retransferring to the first instance court for re-examination if the first instance or regional court decisions are deemed unlawful by the Court of Cassation. Unlike the ordinary justice administrative judiciary, the Constitutional Court consists of a single structure in the Constitutional Judiciary. For this reason, it will be easier to classify and examine the decision made by Constitutional Court. It's necessary to examine the decisions of the Constitutional Court from two different perspectives. The Constitutional Court hears both cases of unconstitutionality and individual application cases. The decision of the court in the two cases are different. In cases of unconstitutionality, if the applied norm is not considered to be unconstitutional, a disapproval decision is made. And if it is considered to be unconstitutional, an annulment decision is made. Individual application cases, on the other hand, if the application does not meet the certain conditions before the further examination, the decision of unacceptable is given. After the file is examined in court, if it is thought to violate an individual's fundamental rights, a violation decision is issued. If it is not thought to violate an individual fundamental rights, no violation decision is issued. So, for the anatomy of judicial decisions in our Turkish legal system, one we see, our organizations directly related to judicial activities. They prepare legal guides for the benefit of persons involved in the proceedings or to standardize the writing of decisions by determining the types of cases, the issues that need to be investigated during the trial, the frequently made mistakes in practice, and the issues that cause the prolongation of the proceedings. The legal guide prepared by the Minister of Justice for Judiciary, taking into account the practices of the high courts. It aims to establish standards for the investigation to be done and to evidence to be collected in each type of case to reduce the reasons that prolong the proceedings, to guide the decision makes correctly at the decision stage, and to ensure the predictability of trial proceedings. This guide contains some substantive recommendations and has not established an order to ensure uniformity in decision methodology. Therefore, it's not a guide that creates common patterns for judicial decisions. In this respect, it does not impose limits on the variety of form and content to decisions in terms of judicial decision. And we have the decision writing guide, which was created by the Council of State, aims to compose the decision of the Council of State in accordance with the common writing style in terms of style, content, and forms. It's important for jurisprudence that the judicial decisions that are formed on the basis of a justification suitable for writing of decision and the legal methodology can be put forward and audited. In addition, the principles of certainty and predictability, which are among the fundamentals principles of law, require that judicial decisions be based on a logical basis and the reasons for the verdict are explained. For this reason, for the correct classification of judicial decisions, it's necessary to determine the conflict, to make the legal qualification correctly, to discuss the evidence, to evaluate, justify the event, and to use legal terms and concepts together in the decision text. However, such a uniformity does not exist within the scope of the Turkish judiciary. Data pool and accessibility. Using computational methods in law is an approach that necessitates that preparation of the materials to analyze. For a valid, reliable, and organized computational analysis, it's necessary to have a clean, pre-processed, and well-built dataset. Applying computational analysis in law has its own limitations for creating such a dataset because of several issues, such as unavailability of legal data, lacking anonymized data, and existing data that is not suitable for the data analysis. On the other hand, even though there could be existing data that is published publicly, it's necessary to process the data such as application of tokenization, lemnisation, and classification. In order to build a legal dataset that is prepared to get analyzed, it's important to clarify what the dataset will contain as the unit of analysis. In the legal context of data analysis, the analysis probably will be judgment-based, decision-based, case-based, justice-based, and so on. If we assume that the unit of analysis will be decisions in the research, then it's necessary to search for decisions in that legal context and specify the details of the process of decision-making as we discussed earlier. Searching for decisions, judgments, and cases can differ from context to context. While some states are publishing the legal datasets publicly, which is prepared for the researchers, some of them are not publishing it anyway, or some other are publishing legal data for only informing those in the legal process regarding the process. So when we look to our Turkish legal dataset situation, we can say Turkish Minister of Justice has digitized the justice system through the National Judicial Network Information System, which we called UYAP. With UYAP, users and judicial bodies exchange all kinds of information and documents electronically. However, in this system, judicial decisions are not open access for the public. Hence, it would not be unfair to say that the main aim of UYAP is more related to management of the process, rather than providing data for researchers and developers. Other important options for gathering data regarding Turkish legal system are datasets that are published by the Constitutional Court, Court of Cassation, and Council of State. Additionally, the private sector can be another source of data, as they are mostly published by companies or lawyers of the companies. However, in this context, we lack knowledge about the reliability of data because there is no confidentiality of data that's provided by private companies. Consequently, the legal data in Turkey is not accessible to researchers in most of the examples that are presented. Even if the data is accessible, it mostly contains a probability of being unreliable or not organized for the purpose of research. Putting the discussion of the availability of data Turkey aside, the existing data cannot be organized for us. In order to have a legal data set that contains Turkish legal data, the data also need to get organized and prepared for analysis. So we encounter the question of how to prepare data for the analysis as a second of creating a legal data set. There are some limitations for preparing the data for the analysis, even if there seems to be existing data. The first step to preparing data for analysis is to overcome these limitations. One of those limitations is the legal data sets that are not published in computer-friendly version of documents. Data providers such as Constitutional Court, Court of Cassation, Council of States are not providing a similar type of data. For example, researchers can download data from Constitutional Court as PDF file and from the Council of States as TXT. Therefore, even though one of the data providers gives ease to gather data, the other can make the process of aggregating data much more difficult. Publishing a legal dataset will gather decisions in only one dataset extended as XLS, CVS version will help us to analyze existing decisions and predict decisions through the training and testing data. The second step for a clean dataset is to ready for analysis. So the big question is for us how to get ready for the process. This question has to be answered by the choosing methodology for NLP and method. To answer these questions, I will give floor to my colleague, Professor Kaplan, which will explain our methodology about the NLP and machine learning methods.
Thank you, Ömer. And I want to show my screen. I think it's already shown, right?
Yes, we can see.
Good. Then, hi, everybody. I'm Ahmet Kaplan from the Ibn Haldun University, and currently working on the artificial intelligence techniques and applied in the finance, economics, and the other areas. When we use the NLP modeling components, especially applied for the Turkish language, we first start with what is the WordNet and how we achieve the whole data about the WordNet and how we tokenize all of with the corpus. So WordNet, in its broader definition, is a highly comprehensive dictionary that's built on the distinct word sense along with their definitions. The most of the words in the WordNet are open class words, such as noun, verbs, adjectives, and adverbs. Main blocks of the WordNet are synsets, which is comprised with the synonym synsets members, and synsets are distinct units in the WordNets, and all the mappings, including intra and interlingual ones, are constructed based on the synsets. In order to construct a WordNet, we, whether from scratch or expanding a previous one, is a very, very labor-intensive process that requires the several steps and extensive use of both human labor and the automated systems. And I want to describe what is the tokenization that we are currently using. We use the tokenization to separate a piece of text into smaller units, which is the tokens. Tokenization can be broadly classified into 3 types, such as the word, character, and sub-word tokenization. Tokenization is the most important steps while modeling the text data. POS tagger means that tagging words with their part of speech. So it's a grammatically category based on their function within a sentence, such as a noun, adjective, verb, or so forth. When we talk about the transformers, the NLP transformers, we must mention about the older architectures, such as the LSTM, long short-term memory networks. Before 2017, the LSTM was the most optimal architecture for the neural machine translation tasks. But currently, actually, they have lots of problems for the sequence modeling and transduction problems, such as the translation and language modeling. But with using the transformers, those problems have eliminated by the sequential nature, and they have introduced, the transformers have introduced the parallelism by relying entirely on the attention mechanism to draw global dependencies between input and output. I will continue with the bird classification and the corpus generation in the next slides. When we use the Turkish NLP models, there are several alternatives, which one the mostly based on the bird, which is a bidirectional encoder representation from the transformers. And BERT is designed to pre-train deep bidirectional representation from the unlabeled text by jointly conditioning both left and right contexts in all layers. As a result, the pre-trained BERT model can be fine-tuned with just one additional output layer to create state-of-the-art models for a wide range of tasks. The convert belt, which is the span-based dynamic convolution, is significantly outperforms the classical belt algorithms. DistilBERT is a small, fast, and cheap transfer model based on the BERT architecture. So by using the DistilBERT, the knowledge distillation is performed during the pre-training phase to reduce the size of BERT model by the 40%. So it highly reduced the model size. And when we use the Electra, it replaced the masked language modeling. It replaced the BERT type of models with the replaced token detection, which looks to be more efficient and produce better results. Let's show, and we will work on also the XLM from the Meta company, previously Facebook company, and we are considering to work with the language agnostic BERT sentence embedding algorithm, LabBC, from the Google. Let me show you the performance of those models. We use the training data from the MC4 corpus, and there are some cased version and uncased versions are those data. And we use the DistilBERT and BERT models, and also the Electra. And by comparing those models, the Electra and the XLM got the most high accurate testing results. And for looking the statistical significance of those models, the blue cells means that the left model is significantly better than the bottom model. So it is when we say that this model is significantly better than this model, then it's the blue, and the red cells means the opposite, that one. When we have a look at those ones, the XLM and the Electra is the better choose instead of the classical BERT case. If we have a look at the corpus data, we got the several corpus data sources. The Canet is the most comprehensive data for looking at the tokens. But I want to mention that those corpus data are formed from the several subcorpora, and they are generally taken from the newspapers and the web pages. Currently, there is no information about gathering data from the legal text while building those corpuses. So those corpuses are highly dependent on the newspapers data. When we have a look to the Turkish language characteristics, there are several problems while working on the machine translation task. The English is the richest language in terms of availability of resources. So therefore, the most analysis methods and algorithms have been first implemented for English. However, the accuracy level of the sentiment analysis tasks for the morphologically rich language is not well enough. And Turkish is the one of the very high dependency on the morphologically rich language category. So it is really related with some morphologically extensions. Let me give an example. For example, there is a one word which is the sağlamlaştırabileceksek. It symbolizes 9 words in English. So and each one is referring for each morphology. Each morpheme is maps to a separate word in the Turkish. So it's a very difficult task for the separating all the morphological part, morphemes. And in the Turkish, there are average of 3 morphemes per word. So it is very highly skewed. So and for example, this word have 9 morphemes, and especially in the legal concepts, it is very important to each morpheme because it changes the meaning of the sentence. So there are a big challenge for this structure. We are currently working on with scrubbing the Turkish law data sets from all the court data and the other data, and for the Turkish legal context. After while scrubbing, we are currently working on the different models, and we will work on the configuring the new labs model from the Google. And for the law-specific words, we are working on how we lemmonetize and classify and tagging all the law-specific words. After that, we will evaluate each models, and we will compare the general corpus data. Those are some general corpus data for the Turkish one, but we should compare with how legal context is affecting on those corpus data. And thank you for listening. And if there is any question, and if there are any questions, we are happy to answer them. Thanks a lot.
Thanks, Professor Kepler and Professor Harold. Do we have any questions? Any questions? If not, maybe I'll ask one because I'm curious to know.
Okay.
As you know, there's a bit of research on a lot of the research in this space has been done on the English language, right? And to some extent also maybe I think the Chinese language as well. How far do you think the existing techniques that these existing techniques that work for maybe predicting English legal decisions, all of these things, how far do you think they might carry over into the Turkish context?
How far? May I get again? How far the methods are? Well, what? I couldn't get.
Yeah, sorry. Let me be clearer. So I was just curious to know, a lot of the research that is currently out there that's done on English decisions.
Yes.
Yeah. How far do you think those papers and those techniques there, they might be applied to the Turkish context?
Oh, I
Turkish
see.
decision?
Let me answer them. Yeah, there are lots of good decision-making models and the very good applications on the English languages, but in the Turkish language, for the morphologically problems, we first solve that each morphological extension, the morphemes, are changing the meaning of the sentence. So we clearly define what is the meaning for each morphological part. And if it is positive, negative effects of the whole sentence. So and I think that we are currently working on the new models such as the BERT and LabBSE, and it's looking for the sentence embedding models. And I think those sentence embedding models getting better results instead of the word search.
Sorry for the yeah, I'm wondering among the languages for which we know of legal NLP techniques having been applied, whether Japanese might actually be analog, because Japanese has, I wouldn't say identical, from what I understand from your presentation, it doesn't exactly have identical rules in terms of word order flexibility, but in terms of morpheme agglutination, it has somewhat of a similar process with its verb endings as well. And as far as I know, they've actually tried NLP in Japan on statutes. So is that a closer analog compared to the more common English and Chinese NLP?
Yeah, that's a good possibility, because yeah, there are some morphologically rich languages, and we may work on those models applied especially for the Chinese and Japanese texts. Yeah, that's a good opportunity for us.
Okay, last question from Doug.
I'm sorry, I might have missed it somewhere in there, but I'm wondering, with what you guys have planned, albeit with difficulty in accessing the data and the NLP problems that you sketched out, do you have a timeline on when you think you might have a suitable corpus or data set? And I'm asking because I'm part of a group with some colleagues that are trying to put together a benchmark for these things, and that would provide an infrastructure where if you have a data set, it should be fairly easy to at least see how these models perform and have all that available. And I just want to know, when should I write you again to kind of bother you with sending us the data set and seeing how well maybe your model does on an international scale.
Let me answer Professor Kaplan for this question. We are dealing with the judicial separation system in our Turkish judicial system. So, as I mentioned earlier, we are not facing the same exact uniforming judicial type of from the cases. So we are going to decide which cases, which the decisions with dealing. And as far as we sum up this level up this, for this question, we will continue with the Constitutional Court decisions because the Constitutional Court decisions types is similar with the European court decisions. That's why we are going to scrapping with the Constitutional Court firstly, which are publicly announced, publicly get accessible from the Constitutional Court, because they are not published all court decisions which made by individual application. So we are going to first gather the Constitutional Court decisions, then we will continue to other decisions such as Council of States and Court of Cassation decisions. So when we do that, we will be happy to share with you and make a collaboration for the further project or studies.
Just a real quick follow-up. I think we tend to overestimate the corpus size because we're always thinking about training. While for benchmark, it's really okay to look for a small size. If we're talking a couple of thousand decisions or something, that would already work just to benchmark, since the training would come from elsewhere. So don't hesitate to reach out.